Thank you. If you will call our last case on the docket for the morning.
State of Tennessee versus George Patterson.
Good morning, Your Honor. My name is Ellison Berryhill. I'm with the Appellate Division of the National Public Defender's Office, and I represent Mr. Patterson. I'd like to reserve 3 minutes for rebuttal.
Thank you.
Your Honor, this has a potential to be a very important case. The charges are not the most important charges. Obviously, they are an A misdemeanor and a C misdemeanor, but the legal issues are very important. There's major constitutional issues here and major rules on how people interact with each other in the state and how human beings can interact with, or how citizens can interact with law enforcement and government employees. But one point I want to make in this argument is that I don't believe that this court has to address all of those issues if the sufficiency of the evidence is not there for the charges as they were presented in the trial court, that we don't have to address any of the other issues. In my argument today, I'm just going to talk about sufficiency of the evidence and the First Amendment constitutional issues. If Your Honor has questions about any of the other several issues in the brief, I'm happy to talk about them. But the ones that I'm going to bring up on my own are the sufficiency and the First Amendment. So the sufficiency, I'll start with the misdemeanor assault on the officer based on offensive contact. The basic allegation is that while the officer was trying to arrest my client kind of did a one-handed push away of the officer's hand, and that is sufficient for, that the allegation is that is sufficient for an assault on the officer.
Is the interaction on video?
Everything's on video.
Okay, so we have that.
There's nearly no disagreement in this case about the facts. There is.
For the benefit of our students, I think it might be helpful for you to tell them what happened here, what we're going to see on the video. Or you may have been heading there, but just tell us a story. Tell us what happened.
I can do that, Judge. My client, he is filming the beginning of the video. He is filming, and it is a video that he takes, and he walks into a post office to ask about a poster that he believes should be hanging on the wall. Pretty quickly, when he's in the post office, an employee says, "You got to stop filming in here," and he says, "I'm not going to do that. I'm on public property. I'm allowed to film." That escalates, and my client is asking about a poster. He calls it poster 7 that talks about the regulations of people being in the post office. And then that escalates to a supervisor coming. Client talks to the supervisor. Supervisor asks him to leave. He says, "I'm not going to leave. I'm on public property." Then the police are called. The police take about 15 minutes to get there from the call. My client is in the mailbox area of the post office because they have locked the door to the area where they do business. And he is in the mailbox area waiting, continuing to film. He moves around a little bit, but he's predominantly over there. The police officer comes in, is talking to the supervisor. Supervisor says, "This guy's here. He's asking about a document we don't have. He won't leave." Officer says, "I'll take care of it." Then officer is talking to my client. My client's making the point, "I don't have to leave. This is public property. I'm allowed to film. I'm allowed to be here." Then at some point, there is a wooden door with a cutout piece in the wooden door, and where one of the post office employees is doing business with somebody through that cutout piece in the door. The client then, they leave that cutout piece open and walk away. The client walks up and starts videoing that through that doorway. They close the door. Client says, "That's how you get privacy." And then the officer says, "We got to go." This is when the perspective will shift from the client's video. The client's video shows all of that, and then the officer's body camera becomes important at this point because he walks up to the client, says, "We got to go." He puts his arm, he grabs the client by his arm. The client pulls away from, or he touches the client on his arm. The client pulls away from that, and then the officer then grabs for the client's hand. Client pushes it away. Officer then picks up the client, carries him outside, at which point the client complies. So those are the facts. Maybe that's more than you were asking for, but
and this case was tried to a jury here in Davidson County.
Tried to a jury. Client was charged with misdemeanor assault on an officer based on offensive contact, resisting arrest, and disorderly conduct. He was acquitted of the resisting arrest charge, which as I go to in the briefs and I'll talk about here, it's kind of interesting. And then he's convicted of the assault on the officer and the disorderly conduct charge. And a lot of my arguments in the brief are about the constitutionality, some evidentiary issues. There's some of that in the brief, but the baseline that I want to make, the baseline point I want to make is even excluding all of that, with the evidence that was introduced at the trial, I don't believe that the case is sufficient to convict him of these charges, of the charges that he was convicted of. And if your honors agree with that, you don't have to deal with all of the other issues. The brief can just end at a sufficiency analysis. So on the assault on an officer charge, the way it was indicted is offensive contact. So it requires that he knowingly caused physical contact with a law enforcement officer discharging their official duties, and a reasonable person would regard the conduct as extremely offensive or provocative. There's examples in the statute that were given to the jury of spitting, throwing, or otherwise transferring bodily fluids, bodily pathogens, or human waste onto the person of a law enforcement officer. There's also State v. Smiley, which is a case that provides more examples of this and says it has to offend a reasonable sense of personal dignity. And examples it gives are kissing somebody without their consent, cutting their hair without their consent, or again, spitting in their face. So the way I view those is they're all very personal things. They're all very kind of either in your person of someone kissing your face or shaving your head or something that's just very gross, like bodily fluids being thrown on you, that is a much more personal, offensive contact than this is, of pushing somebody's hand away. And that these are just different types of behavior. One of the cases that I cite in my brief is State versus Jones, it was talking about a lesser included and whether it should have been included. And it was a tree branch using to strike a victim's backside. This is not a law enforcement. This was in the regular assault context without the law enforcement piece. But whether the court found that was the evidence there was insufficient to support a conviction for this offense, so it was not error to not give that jury instruction as a lesser included offense. And that feels like a very good example of that is a physical assaultive conduct that would not be this kind of assault that he was charged with here.
Even though there are examples like that, I mean, isn't that ultimately a jury question? Because they've got to determine if a reasonable person would regard the conduct as extremely offensive or provocative. I mean, we've all been trial judges. We've applied this statute to a lot of different scenarios that go far beyond those that you're mentioning that are just kind of generally gross and offensive. So
I believe in that case is helpful because it is the court saying that they didn't need to give the jury instruction on that lesser included offense because it would not fit that behavior. That the behavior of hitting the person with the backside would not be.
Yeah, but what I'm saying in this case, this went to the jury, and the jury was instructed that, to find the defendant guilty of this behavior, they would have had to determine that he knowingly caused physical contact with a law enforcement officer that a reasonable person would regard as extremely offensive or provocative.
And I believe that the evidence is not sufficient to support that as it came out in the trial. So as it went to a trial, they heard the evidence as it was presented at the trial, with the video very clearly showing the contact, is not sufficient to rise to that level. And I think the case law is helpful in showing other examples of behavior that the courts have found, or that this court has found, does or does not rise to that level.
But going back to the case that you're citing with the tree limb to the backside, what was the defendant convicted of in that case?
The way it was an assault charge. I don't remember if it was assault or aggravated assault. The argument was whether B misdemeanor assault, which is what this normally is when it's not a law enforcement officer, whether the B misdemeanor assault should have been charged to the jury. And the jury should have been given that as a lesser included. And the court found that it should not have been.
And you think that supports your position?
I do, because he was not charged with a misdemeanor, typically a misdemeanor, what we normally think of as an assault. He was charged with this charge. And the state has to prove the crime they charged. They charged this one. They didn't charge the typically a misdemeanor assault of they charged the offensive contact assault. And that's why I believe that that case supports my position, because this is the charge that they charged here. I think it kind of relates to, there are other things he could have been charged with, and he was also charged with resisting arrest. And I think if he had been convicted of resisting arrest, it would be much harder for me to argue that there's not sufficient evidence for that charge, because resisting arrest requires pulling away or physically resisting being arrested, and the video pretty clearly shows him trying to do that. But that it is not this charge. He should have been charged with resisting arrest. He should have been potentially convicted of that, but he wasn't. He was convicted of this. And the evidence is insufficient to support this charge. I also think it's important to note that this charge has now been made into a felony. $10,000 minimum fine, 6 days to serve without program behavior credits. That is the law on this charge now. Had he been charged or convicted, he would have been a felon and having all the consequences that we've talked about that earlier today. And that seems something that would normally be a B misdemeanor, like resisting arrest, should not be elevated to a felony level. I think if the legislature was likely thinking of things like spitting in an officer's face or throwing feces or fighting with an officer when you are being arrested, and that kind of thing would lead to more of a felony level offense than something like this. So here, he just pushed an officer's hand away. That should not be enough for this specific type of assault that he's charged with. So then I get to the disorderly conduct charge. This is the smallest of charges, but it is important to get right because lots of people get arrested for this charge. Getting this charge right is really important for people who frequently get arrested, maybe down on Broadway, and get held in jail and have problems. Having good law on this charge is really important. The factual allegations, as I was talking about, he went to the post office filming, asking questions, did not leave when they called the police, and that is why he is charged with disorderly conduct. The elements are in a public place with the intent to cause public annoyance or alarm, creates a hazardous or physically offensive condition by any act that serves no legitimate purpose. I agree that one of those elements was met. He was in a public place. The other three I don't believe have been met. The intent to cause public annoyance or alarm, his intent was to ask about this poster, film public servants who he's allowed to do.
For what purpose?
His idea is that he is a First Amendment auditor. He believes that he has the authority to film public servants in public places doing their jobs, and if we do not use our First Amendment rights, we will lose them. That is his perspective on this.
He did not testify, right?
He did not testify.
Was the jury aware that he was a First Amendment protector?
I know it was mentioned in the record. It may have been mentioned in a argument before the judge. I don't remember if it came out in front of the jury, that specific part of it. Okay, so what is a First Amendment protector? First Amendment auditor.
Auditor, excuse me.
So, sorry, I don't mean to.
No, it's new to me.
The idea of a First Amendment auditor is that.
I guess we're First Amendment protectors.
Yes, that is. I agree. The First Amendment auditor is someone who we have First Amendment rights, but lots of people do not use their First Amendment rights in certain situations, such as going into public places, public facilities, and filming. For
what purpose?
Because if you do not use the right, you could lose it. If it is not something, because you see in this situation, this escalated because people were concerned about this, were worried about this, because people don't do that. That is a thing that is not terribly common for people to come into a post office and film, but because he is First Amendment auditor, he is doing that. He is going into these places. He is filming. He is using this right, because if you do not use the right, then there's a fear that it will go away. You will lose it.
Well, do I have the right to take my cell phone and be a First Amendment auditor and go into the bathroom and film somebody?
That is different, Judge, because there's bathrooms are different from a public place and that kind of goes to the First Amendment arguments. The bathroom is a much more protected private place than out in public. So I would not expect that you would have the right to do that, but I think that's a different thing.
Where do you draw the line? I mean, is there no line? I mean, we have rules about videotaping in this room. Would I be in violation of the First Amendment if I wanted to take my camera all of a sudden and start videotaping you make your oral argument and claim I'm a First Amendment auditor, and I have the right to do that?
I think that gets into a question that I don't necessarily think we need to answer for this case. There's a camera right there filming me already, so
You're on YouTube right now.
I have to being filmed in this context. But I think on the elements of the offense, his intent was not to cause public annoyance or alarm. His intent was to exercise First Amendment rights and record in a way that he believed he was allowed to do.
But a jury apparently had a different view of what his intent was. They convicted him.
They did convict him, Judge, but I believe that the evidence is not, that's the sufficiency analysis. I believe the evidence is insufficient to convict him on that. I don't think the evidence that was given to the jury is sufficient enough for them to have convicted him. I agree they disagreed with what I'm saying right now, but that's what the sufficiency analysis is for. An important part of it is the third factor is the hazardous or physically offensive condition. Counsel and I go back and forth in our briefs about this, about what physically offensive condition means. It's not something that is just morally offensive. It is about a sensory, physically offensive condition. It goes to things like somebody who is, again, kind of, would go back to throwing feces around or something like that would create a physically offensive condition in a way that maybe, even if you think that he was being annoying in the way he was doing this, doesn't rise to that level by any act that serves no legitimate purpose. That goes back to our discussion about whether this is a legitimate purpose. But they have to meet all of those elements to convict him of disorderly conduct. I'm about to run out of time, but I think that if there's an escalation, if the fact that it was an argument is part of the reason that maybe the jury found that it was disorderly conduct, the escalation happened from the postal employees. They escalated. My client went in talking, asking simple questions. They escalated it and got into his face. I'm out of time. I promised to talk about the First Amendment issues, but I failed to do so. I believe the briefs address them, though.
General Ball.
May it please the court, your honors, once more, Ben Ball on behalf of the state. I will also confine myself to the issues discussed before, but I think I will probably veer into the First Amendment issue a little bit because I think it is probably pretty hard to discuss the sufficiency of the evidence for disorderly conduct without talking about the First Amendment a little bit. But let's start with the assault on a first responder. The defendant contends that this was not an extremely or offensive or provocative act here. Our case law tells us to qualify this act must be non-inclusive of bodily injury. So we're not talking about the kind of things that normally fall under assault because they're injurious to someone. But non-inclusive bodily injury, and it should offend a reasonable sense of personal dignity. So this is not exclusive to the examples listed. My friend on the other side has made much of bodily fluids being included in this. Certainly, bodily fluids do not have to be involved in the contact for there to be sufficient evidence here. In fact, I would point this court to a case I cited, State v. Meeks, where they talk about this sort of offensive or provocative contact being sort of poke in the head. And it wasn't injurious, but it could be a reasonable finder of fact could conclude that this was extremely offensive or provocative. And what we have here is similar. It is not a poke to the head, it's a slap to the hand. Officer goes to ground, he slaps his hand away. And that's certainly the kind of evidence from which a reasonable trier of fact could conclude that there.
Is it just one slap? I mean, what are we going to see on the video?
Yes, it's not an extended flurry of blows. He slaps his hand away as he goes to take him, and the jury was certainly within its rights to find that was extremely offensive or provocative. Now, turning to disorderly conduct, First, we have to look at the defendant's intent. Judge Easter, this was also my first rodeo with First Amendment auditors. More familiar than I would like with sovereign citizens, but this is my first encounter with First Amendment auditors. For what I can tell, these are folks who are, I don't mean to cast aspersions on them by saying this, but sort of a type of influencer. And I don't mean that necessarily in the bad context, but what they do is they go to various places involving the government, and they film on their cell phones until someone, the goal, as I understand it, is that someone will ask them to stop filming, and they will then reveal what they consider to be government misconduct. But this was never fully explained to the jury. The term First Amendment auditor is mentioned in front of the trial judge, and there might be a stray mention in front of the jury. There's not necessarily testimony about that. In any event, intent is always circumstantial. Defendant can announce one reason for being there, and the jury can still conclude that he had another. And there was substantial evidence here that could allow them to determine that it was his intent to cause public annoyance or alarm. In fact, one of the things they could probably conclude it from is in the video, he often announces loudly that he is not there to disrupt as he is being disruptive. And we do find that this video did indeed make its way to the internet, which was Mr. Whitlow's fear here. He did not wish to be recorded or appear on the internet, which he testified to, and it was. So there was certainly circumstantial evidence from which a jury could conclude that was his intent. We agreed that it was a public place. So we have to have that he created a hazardous or physically offensive condition. So physically offensive. Let's talk about what that could mean. I would contend that this means that the condition itself is a physical one. In other words, it can't be his words or the content of his words. It's the condition he creates. And he meets that requirement here. It is not what he's saying. It's not his position on the First Amendment that is the problem here. It's the act of filming and his behavior as he does it that causes the physically offensive condition in the post office.
Does he talk about his First Amendment goals on the video?
No, he just says he has a right to be there.
Okay.
If I recall, he does not give any sort of extended speeches on the purpose of First Amendment auditors, but he is clear that he is there to film for First Amendment purposes in sort of brief statements. But at the same time, he is filming. So what we have is there are sort of two areas of this post office. There's, like there are many, there's sort of an area where there are P.O. boxes, and there's an area where there's a help desk. Mr. Whitlow is working behind that. That's the area that he eventually goes into, and he's filming Mr. Whitlow, who asked him to stop filming him. He films behind the counter, and he is loudly interacting with the other customers as this goes on. So there was certainly evidence when you watch the video to support that this was a physically offensive condition, which leaves us finally with there must be no legitimate purpose. And this is where I think it is difficult to discuss. Typically, I would try to avoid going into an issue that opposing counsel has not managed to get to before rebuttal.
What other than filming what evidence other than his filming of the whole incident shows no legitimate purpose?
So that's why I think we have to get into the First Amendment here. And so for him to have a First Amendment right to do this filming, this is, as First Amendment rights on government property often are, or always are, this is a forum question. The question is, what is the post office? Is it a public forum? And I would suggest to this court, and as significant federal case law suggests, it is not. It is a non-public forum. This is not the kind of place that people traditionally go to express themselves. And there's case law that indicates that, look, just because this is a place that facilitates communication doesn't make it a place of expression. This is not a town square. This is not a public street. This is not a traditional public forum. It's also not a designated public forum. This is a non-public forum. And as far as the filming, certainly you have a right in a public forum to film government employees. You have a right to film this postal employee if they are on the street in front of his house. What he doesn't have necessarily a right to do is to go and film them at the counter in this non-public forum. The same way that you can film a police officer on the street as he interacts with the public, but you don't have a right to walk into an interrogation room in the back of a police station and film the officer. So he is in a non-public forum. The First Amendment doesn't offer him protection for filming, so there's no legitimate purpose here for what he's doing, except the purpose here is it annoys Mr. Whitlow. So the First Amendment does not provide him with a legitimate purpose here, and it does not protect his actions. And so for that reason, the evidence here is sufficient to sustain his conviction for disorderly conduct. I'll grant you this is an unusual set of facts for this one, but there are multiple ways to commit disorderly conduct, and this is one of them. And the jury was reasonable to conclude that these facts fit. If there are no further questions, I would ask this court to affirm.
Thank you.
Thank you, Your Honors.
Mr. Berryhill, I think you've got all of your rebuttal time.
Thank you, Judge. I want to talk about the First Amendment issues a bit because it does depend on the type of property. We've slightly different forum definitions in our briefs, but essentially there is a public forum that has long been held open for debate. There is a middle ground. There's a non-public forum, which is not by tradition or designation as a forum for public communication. And then there's limited forums that are in the middle ground where they're either held open for a purpose or they're held open for a specific time period. And when they're holding them open for that time period or that purpose, you can have reasonable time, place, and manner restrictions are permissible, but generally the laws are similar to public forums. I believe this is a public forum. I believe this is that first level of public forum. Post offices have long been held as places for public conversation. There's a case, Perry, which we cite extensively in our briefs, and my friend on the other side talks about saying communication, just the fact that people communicate there does not make it into a public forum. But that was about specific individuals' postal boxes in, I believe, a school, not public spaces in a public facility. United States versus Kokinda is a case that we both talk about, and it is about postal sidewalks. They say postal sidewalks are not public. This is the United States Supreme Court. Say postal sidewalks are not public forums or not, but because the whole purpose of them is to get to and from the post office. The sidewalk is not meant to facilitate the daily commerce and life of the neighborhood. It does have some dicta that talks about how it talks about the post office a little bit, even though it doesn't necessarily need to get there, but says that the post office is not purely non-public forum. I think even if we think it is not a completely public forum, it is a limited public forum for the purpose of discussing postal business. That it is at least, you're allowed to go in the post office and talk about postal business. What he was doing in there is asking about a poster. We call it Poster 7, it has a longer name, but asking about a poster that describes the rules and regulations within the post office. And our position is that even if it is a little limited public forum to talk about post office issues, that counts as that. On filming, I think we see more and more that filming is an important opportunity to gather information and know what is happening with the government. We know that police wear body cameras almost all the time to show that what they're doing, and people can look at a video and it's a more objective way of knowing what is going on with the government. This is not the same as the interrogation room. As my friend on the other side said, the interrogation room, if you tried to walk in there, they would throw you out because it has never been open for public business, while the lobby of a post office and what you can easily see on the other side of the lobby, I think is a much more public forum, a public place where people go all the time without any restriction or people throwing them out. So for those reasons, I would ask that your honors find that dismiss this case, or reverse the conviction and dismiss the indictment. Thank you.
Thank you. We appreciate your briefs and your arguments. And we are adjourned, but we're going to stay here and talk with our students a little bit. Lawyers, feel free to stay or leave. Hopefully you all have had an interesting experience. I know it's not like as exciting as maybe